Fourth Amendment requires police to get a warrant before engaging in a search and guides law enforcement personnel in conducting criminal investigations and in searching an individual's body or property. It has its roots in colonial history, specifically in the British government's abuse of its law enforcement powers to prosecute and punish American colonists suspected of being disloyal. The Fourth Amendment imposes significant limits on law enforcement. In barring police from conducting any unreasonable searches and seizures, it requires that they show probable cause that a crime has been committed before they can obtain a search warrant. The warrant ensures that police officers can gather evidence only when they have probable cause. Further, a judicially created ruling known as the exclusionary rule compels law enforcers to carry out searches properly. Established for federal prosecutions in 1914, the exclusionary rule forbids the courts to admit illegally seized evidence during trial. This rule was extended to state court proceedings in the Supreme Court decision Mapp v. Ohio, 1961. In this case, the court overturned an Ohio court's conviction of Dalrymple Mapp for the possession of obscene materials. Police had found pornographic books in Mapp's apartment after searching it without a search warrant, and despite the defendant's refusal to let them in. Critics of the exclusionary rule note that securing a warrant is not always necessary or feasible, and that guilty people sometimes go free because of procedural technicalities. They argue that reasonable searches would not be defined solely by the presence of a court-ordered search warrant. What are reasonable and unreasonable searches under the Fourth Amendment? Over time, the U.S. Supreme Court has established criteria to guide both police officers and judges hearing cases. In the strictest definition of reasonableness, there is a warrant. Where there is no warrant, the search is considered to be unreasonable. However, the Supreme Court has ruled that even without a warrant, some searches would still be reasonable. In 1984, for example, the court held that illegally obtained evidence could be admitted at trial if law enforcers could prove that they would have obtained the evidence legally anyway. In another case that same year, the court created a good faith exception to the exclusionary rule by upholding the use of evidence obtained with a technically incorrect warrant, because the police officers had acted in good faith. More broadly, a warrantless search is valid if the person subjected to it has no reasonable expectation of privacy in the place or thing being searched. From colonial times to the present, the assumption has been that individuals have a reasonable expectation of privacy in their homes. Where there is no reasonable expectation of privacy, however, there can be no unreasonable search, and so the police are not required to get a warrant before conducting the search or surveillance. Since the 1990s, the court has expanded the situations in which there is no reasonable expectation of privacy and hence no need for a warrant. For example, there is no reasonable expectation of privacy in one's car, at least in those areas that are in plain view, such as the front and back seats. There is also no expectation of privacy in public places such as parks and stores, because it is reasonable to assume that a person knowingly exposes his or her activities to public view in those places. The same is true of one's trash, because there is no reasonable expectation of privacy in the things that one discards. Police may search this material without a warrant. In instances where there is a reasonable expectation of privacy, individuals or their property may be searched if law enforcement personnel acquire a warrant from a judge. To obtain a warrant, the police must provide the judge with evidence that establishes probable cause that a crime has been committed. Further, the warrant must be specific about the place to be searched and the materials that the agents are seeking. These requirements limit the ability of police simply to go on a fishing expedition to find some bit of incriminating evidence. As society changes, expectations of privacy change as well. For example, technological innovation has given us email and the internet, and Fourth Amendment law has had to adapt to these inventions. Is there a reasonable expectation of privacy in our communications on the internet? This is an important question, especially in light of citizens' heightened concerns about terrorism and white-collar crime. The Fifth and Sixth Amendments establish the rules for the conducting of a trial. These two amendments ensure that criminal defendants are protected at the formal stages of legal proceedings. Although less than 10% of all charges result in trials, these protections have significant symbolic and practical importance, because they hold the state to a high standard whenever it attempts to use its significant power to prosecute a case against an individual. The Fifth Amendment bars double jeopardy and compelled self-incrimination. These safeguards mean, respectively, that a person may not be tried twice for the same crime or forced to testify against himself or herself when accused of a crime. These safeguards are meant to protect people from persecution, harassment, and forced confessions. A single criminal action, however, can lead to multiple trials if each trial is based on a separate offense. The Sixth Amendment establishes the rights to a speedy and public trial, to a trial by jury of one's peers, to information about the charges against oneself, to the confrontation of witnesses testifying against oneself, and to legal counsel. The protection of these Fifth and Sixth Amendment liberties is promoted by the Miranda rights, based on the Supreme Court decision in Miranda v. Arizona. In the Miranda case, the court outlined the requirement that prior to questioning, the person must be warned that he has a right to remain silent, that any statement he does make may be used against him, and that he has the right to the presence of an attorney, either retained or appointed. Later cases have created some exceptions to the Miranda rights. The last part of the Miranda rights with the ability to obtain counsel is from Gideon v. Wainwright. Together, the Fourth, Fifth, and Sixth Amendments ensure the protection of individuals against abuses of power by the state, and in doing so, they promote a view of justice that the community widely embraces. Because these rights extend to individuals charged with violating the community's standards of right and wrong, they promote a broad sense of inclusiveness, a respect even for persons who allegedly have committed serious offenses, and a desire to ensure that the justice system treats all people fairly. The court has considered the community's view in reaching its decisions in cases brought before it. For example, through a series of Supreme Court cases culminating with Gideon v. Wainwright, the justices interpreted the right to counsel to mean that the government must provide lawyers to individuals who are too poor to hire their own. The justices adopted this standard because they came to believe that the community's view of fundamental fairness dictated this result. Before this decision, states had to provide attorneys only in cases that could result in capital punishment.